Well, like I said, the two triggers for having a trust-based plan is, do you own real property? And the other one is, do you have children? If you have children, then whatever you've accumulated in your life, you want to make sure that you pass it on to your children, not only in a tax-efficient manner, you want to make sure it's protected for your children. So, for instance, the way our estate planning documents are drafted is that they are designed to follow the bloodline. Okay, sometimes people ask me, what does that mean? Okay, let's say, your son or daughter gets married and they have children, so you've got grandchildren, and God forbid, terrible accident or something happens and your son or daughter happens to predecease you, leaving these children. And then when you pass away, where does your stuff go? It was designed to go to your son or daughter, but if that son or daughter has predeceased you, what happens? Well, if the documents are designed correctly, they should follow the bloodline, which means if it was your son who predeceased you and left 2 kids, then your son's dispositive share from your trust would flow down to your 1 or 2 or 3 grandchildren, whoever he left, so that that the bulk of your estate or all of your estate is going to ultimately benefit your heirs. Not to say that you don't, love your daughter-in-law or son-in-law, but the point is what you've accumulated for, your son and his issue. And so that's really the way it's supposed to be done. And the other reason is really a practical reason for it too. I mean, God forbid your son does predecease you and then his wife gets remarried. Well, what happens then? And if something happens to her, then if all the assets that she would have inherited from you, instead of going to your grandchildren, ultimately goes to this new husband who you didn't know or didn't meet and certainly didn't intend to have your stuff go to. So from a very practical standpoint, the trust is usually drafted to follow the bloodline. That's the correct way to do it. The other thing that we do with a trust plan when you have children, you might want to make sure that the money is managed for your children in a certain way over a certain period of time. I've got certain clients who, got one client in particular who's got 2 sons. One is 18 and the other one is 21. And right now, the 18-year-old could take over and run IBM. He's that squared away. The 21-year-old, however, if he were to inherit a bulk of money today, the Ferrari would be parked in the driveway tomorrow. So, as a parent, you have to be sensitive to that and say, okay, if I have a child who is going to be perhaps foolish with their money, do I want to set up my trust-based plan in such a way that this child is going to get his share, maybe a third at 25, a third at 30, and then maybe the balance at 35 or 40 after they've accumulated some maturity and have made some money on their own. And very often, that's the way I counsel my clients that have younger families, is we want the money managed for their children, and we try to tie it to certain events. A lot of times we try to tie it to 21, perhaps graduating college, 25, starting a business, 30, 35, buying a house. And at that time, the kids can appreciate the money more and use it in a more responsible fashion, which is what you want. The flip side of that is, I've had clients that have children that are totally irresponsible. It's really unfortunate, but there's the financial irresponsibility that some people may have. And then other children, and again, this is life. I mean, welcome to my world. We have children who have substance abuse problems. And what happens if they're going to inherit a sizable sum of money and they've got a drug problem or they've got an alcohol problem and that the money is just going to get squandered? Having a trust-based plan that provides for that child to have his or her dispositive share managed for a number of years, you can ensure that at least if they don't find the error of their way, so to speak, in a certain amount of time, that God forbid if something happens to you, at least there's money there to put a roof over their head and feed them and take care of them. And you have to have someone in charge who's going to do that. That's probably the most difficult thing when you're faced with that prospect is, who do I leave in charge to manage that money for my son or daughter who's not going to use it responsibly? But those are 2 of the biggest reasons to have a trust-based plan when you have children. The other, and this is again a more practical scenario, Your son or daughter may get married, and hopefully, as in my case, I love my son-in-law and I love my daughter-in-law dearly. They're great people, squared away. But what happens, if your son marries Bambi the barmaid? And then, she decides after, 5 or 10 years, I'm getting divorced. I'm running away to Mexico with this guy I met at the bar. Send me my half of our community property. Well, if your son has inherited a sizable amount of money from you and he just inherited it to himself, it becomes part of his community estate with his wife. Whereas if you've left your son's share in a separate share trust that he can manage during his lifetime, you basically asset protected it from something like a divorcing spouse or a terrible lawsuit or an IRS audit. So very often, I counsel people that, when you're going to leave something to your children, what about leaving it to them in what I call a children's trust so that it's asset protected? And people will say, well, how do they get money out of the trust? Well, your son or daughter can be the trustee with someone else. And if they need money, it's kind of like having the money in a tube of toothpaste. If your son decides, well, I need $10,000, I want to buy a new car, he squeezes that tube of toothpaste a little bit and he takes out the $10,000 and he goes and buys the car. But the rest of the money is still in the tube of toothpaste. It's in the children's trust. So if something bad happens to him, if he's audited by the IRS and has a horrendous tax problem for some reason, not even the IRS can get what's in the children's trust because while he may control it, he doesn't own it. And so as a parent, you can offer that kind of asset protection planning to your children. And to my thinking is, why wouldn't you want to do that? But a lot of lawyers don't talk to their clients in terms of that. And one of the things, the three most terrible words that I read in a trust sometimes when someone is considering that is the words are free of trust, because most lawyers, when they draft a trust, say, okay, this goes to my children free of trust. And that means it doesn't give them the option, it goes to them outright free of trust. So now it becomes theirs. And it becomes their responsibility to keep it separate if they're married, if they want to retain the character of that property as separate property. But then even as separate property, it's in their estate. So it's not asset protected. And if you've got the option, and I love having options in life, we never know what's going to happen. None of us have a crystal ball. So if you've got the option to set up a children's trust that your son or daughter can squeeze money out of that trust on an as-needed basis, but otherwise keep it protected there safely, it's like, why not do it that way? And following up on the situation with children, obviously, a lot of the planning I do is for people that have minor children. And with respect to minor children, obviously, God forbid something happens to you. And let's say, you've got $1 million life insurance policy, you've got $1 million house, and you've also got a 5-year-old child. And if something happens to you, obviously that child can't manage, a $2 million estate. So you want to make sure that in that instance, and especially with life insurance, a lot of us will have a life insurance policy and we'll name our spouse as the primary beneficiary and our kids as secondary beneficiaries. Well, when you've got a minor child and you've got a big life insurance policy, if God forbid something happens to you and your wife in a common disaster, well, that child is going to inherit the proceeds from that $1 million life insurance policy as soon as they turn 18, because it'll go into a blocked account under the Uniform Gift to Minors Act while they're a minor. But then the minute they turn 18, if they're the beneficiary, they get use and access of that money. So even if you've got this great trust drafted that says the money's going to be managed for my kid and here's when they're going to get it, at 21, at 25, at 30, well, in that instance, if the beneficiary designation of the life insurance policy isn't done properly to have it flow into the trust, that plan's going to blow up. Kid's going to get the money at 18. That may or may not be a good thing. I mean, most 18-year-olds I know really not very astute at handling $1 million estate, but it happens. So if you've got a trust-based plan and you've got minor children, you want to make sure that you're coordinating beneficiary designations on things like life insurance policy for that reason. The other thing that happens, forget about minor children, what happens if you have a disabled child? I've got a couple of friends who have kids who are autistic. And I've got one friend who's got a son, very high functioning, graduated college, but still he's not going to be in a position where someone is not going to have to manage his money for him. Okay, he still lives at home. When something happens to his parents, we have a special needs trust set up for him that actually his younger brother is going to manage as the successor trustee, which is a perfect scenario. The younger brother is, solid, squared away kid right now. And when and if that event occurs, he'll be old enough to manage his brother's money so that his brother is taken care of properly throughout his life. Because otherwise, the reason we all also do that, in this case, there's going to be plenty of money to provide for his adequate care and comfort. Some people, though, with special needs, they depend upon public benefits to make that gap so that they do have enough money for basic necessities. And if you leave a significant estate to someone who has special needs under the current law, they've got to burn up that money before they're eligible for the public benefits. So by having a special needs trust, that money in the special needs trust is not considered as an immediate resource, so that the son can still qualify for his public benefits, and the money in the special needs trust can be used to enhance his life as opposed to providing for basic necessities. So, having kids, special needs children, minor children, important considerations. So again, if you have children, if you have a child with special needs, if you come from a blended family, those are all going to be reasons why you need a trust-based estate plan, and we can show you why. To bring this full circle, if you want to take advantage of talking to me, there's going to be a link at the bottom of the website where you can schedule some time to do that. On the other hand, if you're adamant about trying to do this yourself, I know there are websites out there that try to guide you through this. They're mostly cookie cutter type websites that really don't provide for a lot of the eventualities. So I've got another link to a different site that is a little bit more robust plan that will help you go through a question and answer period to design hopefully a more proper plan if you want to try to do it on your own.